President Obama has just finished an emotional eulogy for Reverend Clementa Pinckney, one of the 9 gunned down at a church in Charleston. We'll discuss the president's comments on race, guns, and faith. But first, it was another historic day at the Supreme Court. Marriage equality is now the law of the land. It's Friday, June 26th, and this is Now.
All Americans are treated as equal.
Same-sex marriage will be the law of the land.
We as a country can finally turn the page from national discrimination.
Kids no longer have to question why their parents were deemed unworthy.
Marriage equality will now be seamless coast to coast.
The historic precedent that is likely to last for generations to come.
The 4 words etched onto the front of the Supreme Court, equal justice under law, apply to us, too.
It is really remarkable how the court sort of led the country in this direction.
Love is love, family is family. Discrimination against love or family is wrong.
Today, we can say, in no uncertain terms, that we've made our union a little more perfect.
It is an historic day for civil rights in America. Today, the Supreme Court delivered a long-sought victory for the gay rights movement, ruling a constitutional right to same-sex marriage nationwide. In a 5-4 opinion, Justice Anthony Kennedy wrote for the majority, "No union is more profound than marriage, for it embodies the highest ideals of love, fidelity, devotion, sacrifice, and family. The petitioners ask for equal dignity in the eyes of the law. The Constitution grants them that right." Hours later, President Obama hailed the decision.
This ruling is a victory for America. This decision affirms what millions of Americans already believe in their hearts. When all Americans are treated as equal, we are all more free.
Each of the 4 conservative justices wrote his own dissent. Chief Justice John Roberts. The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent. Justice Scalia called the decision a threat to American democracy and a constitutional revision by an unelected committee of 9. But attorney Mary Bonoauto, who argued for the plaintiff before the court, called the ruling a victory for gay rights and the Constitution.
Make no mistake about it. Today, the court stood by a principle in this nation that we do not tolerate laws that disadvantage people because of who they are.
Today's ruling marked the culmination of a sea change in public opinion over recent years. In 2004, constitutional amendments banning same-sex marriage passed in all 11 states in which they were on the ballot. Today, it is legal in all 50 states. Joining me now is the lead plaintiff in the same-sex marriage case, James Obergefell. James, congratulations. Tell us first about your reaction to the decision today.
Thanks, Alex. It's great to be here. I'm thrilled. Sitting in that courtroom, I felt more like a full American citizen than I have in quite some time. And I'm just thrilled that my story, my love with John, has led to nationwide marriage equality. It's an incredible thing for me to be experiencing.
James, for the people who don't know the extraordinary hurdles that you and your partner faced to get married, can you tell our audience what you guys had to do?
Right, so when we decided to get married, it was 2 years ago today when I proposed, when the Windsor decision was released. And John was dying of ALS. He was bedridden and in at-home hospice care. So unfortunately, we couldn't just go a few blocks to our county courthouse in Cincinnati. We had to go to another state. And after doing some research, we decided Maryland was the place to go. But that meant we had to charter a medical jet in order to get John there safely and comfortably. And luckily, our family and friends wanted so much to help make that happen. They wanted us to marry, and they wanted to be part of it. They gave us gifts of money in order to pay for that entire medical jet.
We know that John passed away almost 2 years ago, James, and one of the things that Justice Kennedy said in his writing for the majority was that marriage endures even after death, and I feel like that is no truer anywhere than in the relationship perhaps that you have.
It meant a lot to me to hear him say that and to read those words, because that's all I've been trying to do for almost 2 years, since the moment John died. I've just been doing my best to live up to my commitments to him, to love, honor, and protect him. And from the start, we were only asking for dignity and respect, the same that any other married couple would receive.
James, the day is yours. Thank you so much for your time.
You're welcome, Alex. Thanks for inviting me on.
Joining me now is Professor of Constitutional Law at NYU, Kenji Yoshino, and Supreme Court expert, publisher of SCOTUS blog, Tom Goldstein. Kenji, let's first start, with the opinions, for people, for even casual observers of the court. Justice Kennedy's opinion, writing for the majority, seemed almost poetic. Talk to me a little bit about how you read it.
Yeah, it was a lyrical and a soaring opinion, but for me, I think what's been undersold is that it bears a really striking resemblance in terms of the doctrine to Loving versus Virginia.
Yeah.
Because famously, Loving versus Virginia, which in 1967 struck down bans on interracial marriage, said this is a matter of liberty and it's a matter of equality, and either ground is enough on its own to strike down the statute. If you read through the Obergefell decision that Kennedy wrote, essentially what he's saying is the 14th Amendment Liberty Clause and the Equality Clause both come together in order to invalidate these bans on same-sex marriage.
Tom, talk to me a little bit about the fact that each justice wrote his own dissent. How unusual is that, and what do you think that sort of represents in terms of the split?
It's a striking statement. The dissenters are incredibly upset. It's not that they are personally opposed, they say, to same-sex marriage, but rather they think that this is not the job of the courts, but rather it should be decided democratically in their mind, that is through the legislatures. And they feel so strongly about it that each one of them wants to make that point separately rather than doing it all together, notwithstanding the fact that there isn't a ton of disagreement between them. So I think they went well out of their way, including when the Chief Justice openly read from his dissent on the bench today to point out that they thought the decision was wrong-headed.
I was really struck by some of the language in Justice Scalia's dissent, Kenji. It seemed almost personal, some of the language he used. At one point he says, the opinion, speaking of the majority opinion, is couched in a style that is as pretentious as its content is egotistic. The opinion's showy profundities are often profoundly incoherent, and this is the one that set the Twitterverse aflame. The Supreme Court has descended to the mystical aphorisms of the fortune cookie. That seems really personal.
Yeah, Justice Kennedy is really known for his florid style.
This is Scalia that we're talking about.
Right,
yeah.
But in the majority, Justice Kennedy is often known for his florid style, and I think that it's a bad combination with Justice Scalia's own acid style, right? So when they disagree, I think it's very easy for Scalia to pull quotes out of his, opponents. And he's often said, one of the reasons that he says that he gets along with Ginsburg as a personal matter, because even though they're ideologically polar opposites, they get along together very well personally. He said, maybe somebody that far away from you disappoints you less. So I think that with Kennedy, who's very close ideologically to Scalia on many issues, right, can disappoint him more. And you could hear that disappointment, I think, in every page of the dissent.
Well, Tom, we know that Scalia signed on to Roberts' dissent. Roberts did not sign on to Scalia's dissent.
No, when the Chief Justice saw Justice Scalia dial it up to 11 and just take out all the knives, I think he said, I think I'll take a step back here.
I got to come back to this bench.
Yeah, exactly right. And he wants to be a leader of the institution. His dissent is strong, but still much more respectful.
Let me ask you, Tom, following on sort of Justice Roberts and the issues that he sort of took with this decision. At one point he says, who do we think we are, that we justices should not be making these decisions? Explain how you think that is consistent or not with Roberts' previous decisions and how he's explained them.
It's very, very hard for any member of the Supreme Court to say, look, I think we should be allowing these things to be decided by the legislatures, because everybody has things that they think are unconstitutional. Think of Citizens United, which is a big decision against campaign finance reform. Think about Shelby County, the decision striking down major parts of the Voting Rights Act. Those were joined by the Chief Justice, and he was a real leader in those areas. So everybody is a bit of a hypocrite when they say, look, we should be judicially restrained and not be striking things down.
What I was also struck by, Kenji, and I think this is a sign of the changing times, is both Scalia and Roberts make a point in their dissents to say, we don't necessarily have an issue with the idea of gay marriage per se.
Right.
It's the way that this decision is being made is what we take issue with.
Exactly. So I think that it really shows, I mean, your earlier poll shows that a majority of the American people now are for same-sex marriage, but also, just as importantly, if not more importantly, the trend line is very much in the, so nobody wants to be Roger Taney, who wrote Dred Scott, right? So all of them, not just Chief Justice Roberts, so I agree with Tom that the Chief is particularly worried about institutional legitimacy, wants to be seen as a bigot by future generations. So I think that they make their own personal priors really clear as a means of protecting themselves, saying this is just a constitutional issue and
Right.
the question of who gets to decide, and I'm not going to wade into the waters of how I personally feel about this.
Right, nothing personal. This is just how the system should work. Tom, before we go, I mean, can we know that there are a couple outstanding decisions, among them a big decision on the EPA, one on redistricting and gerrymandering. Do the huge, I would call it a sort of wins for the progressive end of the bench, do these cases and the decisions this week inform anything about what we might see next week?
I think that you have to take each decision on its own, and the conservatives are probably going to gain back some ground on Monday when they win some rulings on the death penalty, on the environment at the very least. But you just have to look at the term as a whole, and you say, this is by far the most progressive liberal decision of the Roberts Court era and probably of the last quarter century. On the major decisions of the term, the left held together and got a majority in a substantial majority of them.
It is a big, big day in a really interesting season of court decisions. Tom Goldstein and Kenji Yoshino, great to see you guys. Thanks for your help.
Thanks so much.
Alex.